Welcome back, everybody, to Criminal Law. In this lesson, we're moving on to the next major topic within the sort of broader chapter on criminal liability and the nature of a crime and the components of criminal liability. Talking about an issue that is very important and often adds to the complexities of modern case law on this matter. This is the question of parties to a crime or participation in criminal activity, for example. So we're going to move on from looking at the specific elements of criminal liability. So the specific elements of criminal liability, of course, refers to the actus reus of an offence, the mens rea of an offence, things like strict liability, recklessness, intent, things like omissions and causation, to one of the subsidiary issues, which looks at the idea of real-world cases in criminal law, which is exploring circumstances where there is potentially more than one defendant, or offender, someone who is participating in the commission of a criminal offence. This is the idea of parties to a crime. All textbooks on criminal law will begin this topic by defining their terms. And there's one thing that you will learn about the criminal law is that there is not an agreement on the terms in these areas. So I'm going to talk about how we're going to define our terms in these lessons, looking at parties to a crime. So some books will use D to refer to a defendant, and then they will use A to refer to the accessory, so a secondary defendant who is an accessory to the crime. Others may use P to refer to the primary defendant or the principal defendant, or the perpetrator, and then use D to refer to the rest of the defendants. What we shall be doing is using the following terminology. We will have D1 and D2, D1 being the primary defendant, D2 being the secondary defendant, or maybe the accessory, or the person who has aided and abetted, for example. And then, just like with all the other lessons, we're going to refer to the victim by using the letter V. This is how we're going to do it, okay? Some confusion is had when you go from textbook to textbook looking at the various different ways in which they define their terms, okay? So let's think about accessory liability in more detail. When we think about somebody's participation in criminal activity, or the parties that can exist in relation to other defendants, we are talking about a concept of an individual being liable for an offence by way of something known as accessory liability. This is where you catch liability, you become liable in law, and you become prosecuted because you're an accessory to the crime. And the concept of liability for an accessory offence is found in Section 8 of the Accessories and Abettors Act from 1861. So quite an old piece of legislation. And what it says is, whosoever shall aid, abet, counsel, or procure the commission of any indictable offence, whether the same be an offence at common law or by virtue of any act passed, shall be liable to be tried, indicted, and punished as a principal offender. So what this provision does is outline a number of different ways in which you can be an accessory to a crime. A number of different ways in which you can be a secondary defendant, or you can be a secondary participant. This is through aiding, abetting, counsel, or procuring the commission of any indictable offence. It doesn't matter what kind of offence it is, whether it is a common law offence, for example, like murder, or whether it may be a statutory offence, by virtue of any act passed, for example, sexual offences. Ultimately, the legislation gives us the main elements. We have aiding, abetting, counselling, and procuring. These are the different ways in which an individual may be liable as an accessory to an offence. Now, the legislation is relatively clear in how it is established, but it won't be until 2016 when we see some quite significant case law on the matter coming from the Supreme Court. And the case of Crown and Jogi, or Joji, is quite interesting here, because what happens is we have an appeal from two similar cases. We have a defendant who was convicted of murder for a murder which was committed by another individual. They were convicted for murder. They were convicted, and the murder was committed as part of a criminal joint enterprise. The issue in this case specifically pertains to the mens rea of criminal participation, because even though we're talking about accessories or aiding and abetting, we still have to think about the actus reus and the mens rea for these offences. And ultimately, the defendant had, quote, foreseen that the murder would have happened on the basis of being part of this criminal enterprise, and it was held by the Supreme Court that merely foreseeing the relevant events ought not be equated with the principle of assisting or encouraging, and so as a result of which you cannot be held liable for simply being part of this criminal enterprise, seeing or foreseeing that a murder will take place, and equating that with the active assistance or encouraging of an offence. We'll get into the mens rea in more detail in future lessons, but what is important to note is that the concepts of assisting and encouraging are essentially just conceptualizations of the previously cited aiding, abetting, counselling and procuring, which was found in the legislation. So we can see here that the language shifts slightly from aiding, abetting, counselling and procuring to just assisting and encouraging, which is still there are two ways in which we can still highlight both the active contributions to the offence themselves and therefore giving rise to secondary liability, but also the active encouragement of an offence committed by a principal defender, i.e. counselling and procuring. Welcome back everybody to Criminal Law. In this lesson what we're going to do is talk about parties to a crime in a little bit more detail, continuing this section on essentially asking the question, what is a crime? Where does criminal liability arise? We've been thinking about things such as the actus reus of an offence. We've been talking about the mens rea of an offence, talking about things like causation and omissions. And we're now getting on to looking at this idea of secondary liability and the modes and means by which secondary liability can be obtained. And that's what this lesson is going to talk about as well. We're going to talk about what it means to essentially aid and abet the commission of a criminal offence. So this lesson is going to examine the first two actus reus elements, which gives rise to secondary participation. So there are other ways in which we can talk about the different ways in which we can essentially contribute as a secondary party to the commission of an offence. But the first two of these is this idea of aiding and abetting in the commission of a criminal offence. Now, what do these terms mean? That's the first question that we should really ask. Well, the first one, aiding, essentially refers to a secondary defendant, so somebody who is party to a crime, acting in a way which assists the primary defendant in the commission of an offence. Very simple. They aid the other individual in the commission of an offence. The idea of aiding need not necessarily be something which the primary defendant has knowledge or even knowledge of, but this is often the case. So you could have a situation where a secondary defendant has aided in the commission of an offence, therefore satisfying the actus reus element of this particular example, but have done so without the knowledge of the primary defendant. They just happen to just aid without them, or without their knowledge themselves. And we can have a look at the case of Brown from 1968, which is actually an Australian case, so be careful to cite it as an example in a problem question, because of course it's not binding in this country, but at least it gives us some kind of indication as to the ways in which questions of this nature have been applied in common law jurisdictions. And essentially we have two defendants in this case, D1 and D2, and they had an arrangement where the secondary defendant, D2, would assist the primary defendant in the commission of a murder. Now, I've put in brackets here that there were questions relating to the issue of duress, i.e. the extent to which the secondary participant was under duress in the commission of the offence, but we're going to just sort of skip over that and ignore that for this particular example, because we're going to talk about duress in future lessons time anyway. D2 would provide the primary defendant with knowledge of when the victim was going to leave their room, and they would do so by simply coughing. And then this would essentially provide a signal for the primary defendant to then go and commit the murder. Now the question here is, could something as very little as coughing be enough to aid in the commission of a murder and therefore give rise to criminal liability, obviously being very much significant sanctions in the case of murder? Could something like coughing essentially apply in this regard? Well, the defendant was held criminally liable for aiding in the murder of the victim through the action of coughing. And one of the reasons for this is because regardless of how little an action, something like coughing, can be in terms of just objectively what kind of action it is. It's not doing that much in terms of helping an individual. It is enough to aid in the commission of the murder, especially when this is a prearranged situation, where it is prearranged that they have made these come to this conclusion, they've come to this agreement. Hey, I'm going to go and murder this person. I need you to cough to give me as a signal, as a sign. Well, then that should be sufficient in the aiding of the murder, in the commission of the murder. Abetting is slightly different, because essentially what abetting does is refer to the encouragement of an individual to commit an offence. Now, when it comes to the idea of encouragement and abetting in the commission of offence, this is something that must be communicated to the principal defendant, and the principal defendant must also obtain encouragement from it. So it's not necessarily helping them out in a way, which essentially would suggest that otherwise they would not be able to commit the offence in the same way if they did not have this other person aiding them. It is simply essentially egging them on in a way, allowing them to have certain amounts of encouragement. Now, there are two elements that are required here for aiding and abetting, or for abetting specifically, should I say. There is this idea that encouragement must be communicated to this principal defendant. You can't say that this person was encouraging the other person if there was no communication between the two. If they were just, if that was it, there was nothing in terms of a link between the secondary and the primary defendant. And it also must be the case that the principal defendant must obtain encouragement from whatever that communication was. So not only must there be a communication, but that communication must also be one which requires a certain amount of encouragement. But just like in the case of aiding, the idea of encouragement, the idea of abetting in the commission of offence, can also be a very, very small act or a very, very small kind of communication. And if we go to the case from 1997 of Ginietto, we see here that a husband was told of a plan to murder his wife. And I put in brackets here, quite an objectively uncontroversial statement, not a particularly happy marriage. Now, the response to this plan of potentially the murder of his wife was the quote, "Oh goody," suggesting, in this case, that they were particularly happy with this idea, or that they were pleased with the plan to murder his wife. And it was held that the act of shouting that response to the proposition of murder, to the proposition of a plan to specifically murder his wife, this was sufficient for the establishment of encouragement in the commission of an offence. And you can understand quite easily why this would be the case, because not only can you understand the communication aspect, of course that is pretty trivial in terms of our understanding. The response to the plan was the response of "Oh goody," clearly communicated to the primary defendants. But you can also understand, and it'd be quite trivial, that a husband being told of the murder plan of his wife, responding with "Oh goody," suggests at least that it would be something that he was encouraging, and something that the primary victim could take encouragement from, or should I say the primary defendant could take encouragement from. And so as a result of all this, you can understand why this was conclusive to being the abetting of an offence. Now, when we talk about the case law on these issues, we see that it's led to some interesting conclusions. So, for example, one of the most important and leading cases on this is a case which we're going to get to in the next slide, which tells us that the mere presence at the scene of a crime, just being there in and of itself, without any kind of action, without any kind of encouragement, without any kind of communication to the principal defendants, is not sufficient to derive criminal liability for aiding and abetting. And the case of Crown versus Clarkson is the most substantive in terms of understanding this particular matter. So the facts of this case are as follows. We have an accessory who was charged with the aiding and abetting of the rape of a woman. Now, it was actually multiple rapes, or at least this person was raped multiple times. The victim here was raped 3 times in an army barracks, where the alleged accessory, and others had made the decision to enter the room and simply watch. Okay, not a particularly pleasant set of circumstances. And from the evidence given in the trial, there was no suggestion that there was any kind of act or any kind of communication that was delivered by this accessory defendant in terms of assisting or encouraging or aiding and abetting the principal defendant in the commission of this offence. They simply walked in and watched. Okay. Now, it was held that the mere presence of the accessory in the room was not enough to amount to a show of encouragement without an intent to encourage. And this was the case even if the principal defendant did gain encouragement from the presence in the room. And the one of the things that is stated here is that it is, in my opinion, to constitute an aider and an abettor, some active steps must be taken by word or by action with the intent to instigate the principal or the principals. Now, this is a relatively controversial judgment, not one that I'm particularly happy with in terms of how it essentially is presented, because on the one hand, the idea of abetting, as we know already from earlier on in this lesson, requires there to be a communication, and then it requires there to be encouragement. Now, while there wasn't communication per se, there was at the very least encouragement by the fact that being in the room and simply watching implied to the principal defendant that what they were doing was something that they were not going to stop them from doing, and so would, all likelihood, and could have, or in all likelihood, led to them being encouraged to continue in the commission of this offence. So to suggest that there could be no criminal liability for just simply sitting, standing by and watching is quite interesting. But of course we know already that the criminal law and the law in general doesn't like to place liability on omissions very often. Omissions, there has to be quite a high bar set for liability to arise from the failure to perform a certain action. And so this is kind of reflective of that particular principle in the criminal law. So in the previous lesson, what we did was talk about the concept of aiding and abetting as part of the general idea of secondary participation in a crime, in the commission of an offence. This lesson is going to talk about the next two methods by which you can act in a way that is essentially giving rise to liability as a party to the crime. This is through counselling and procuring. So what we're going to do is we're going to essentially do what we did in the previous lesson, where we explored the legal principles underpinning the concepts of aiding and abetting, and we're going to talk in more detail about the second two, which is of course counselling and procuring. And we're going to do so in a similar way to the previous lesson. We'll talk about what these things mean, how they're applied in law, and then illustrate this with a few different case examples. So, given that we're talking about counselling and procuring, let's begin with the first of these. This is the idea of counselling in the commission of an offence. To counsel in the commission of offence is to essentially act as an advisor, or to solicit in the encouragement of an offence before the offence takes place. This is one of the things that's quite important. And we can illustrate this point by looking at the case of Crown versus Kalheim from 1985. So the facts of this case are as follows. The defendant in question was convicted of murder. They were convicted of murder under a provision of Section 8 of the Accessories and Abettors Act from 1861. She had acted as a counsellor in the murder of the victim by the principal defendant. So the person who was the defendant in this particular case was the, quote, counsellor, the advisor in the murder of the victim, by a principal defendant who, of course, also was very much found guilty of murder. While the principal defendant had been counselled to perform the murder by the accessory, by this secondary person, they did not go along with it at the time. It was only when the victim carried on screaming that the principal defendant, quote, went berserk and then killed the victim. Okay? And so at the trial level, the jury was instructed to regard the idea of counselling within the meaning of Section 8 of the Accessories and Abettors Act from 1861 to essentially mean inciting, soliciting, or authorising. A would then appeal her conviction. So this secondary defendant, in this case would appeal the conviction on the basis that she argued there was not a causal connection between her counselling and the ultimate reason P committed the murder. So when we get to then the Court of Appeal, the Court of Appeal argued that the act of counselling did not require this kind of causal connection. They argued that the trial judge was in fact correct in delivering the direction to the jury vis-a-vis what constituted the counselling itself. So this is quite interesting here. So the Court of Appeal makes it very clear that in order to essentially come to a determination as to what counselling refers to within the context of Section 8 of the Aiders and Accessories and Abettors Act, they look towards including within the idea to be read in conjunction with the idea of inciting, soliciting, and authorising. And so this is what it essentially means to be a counsellor in the commission of some kind of criminal offence. Procuring is slightly different because procuring is actually incredibly broad and could actually arise in a huge variety of circumstances. A procurer will cause a crime to be committed, for example, and this is exactly really what the general understanding of what procuring is to mean within the context of this particular area. So causing a crime to be committed is something of a very broad mandate and could involve a whole host of different things. Procurement may be incredibly active in terms of things done, so it could be being very much within the context of the crime, getting involved quite heavily in the procuring of the offence. It could also be incredibly innocuous, but still result in the crime being caused. In addition to this, an accessory may still be liable for procurement even if the principal defendant is acquitted. This is often done on the basis of duress, so they can claim that they are found not guilty on the basis of the defense of duress. But that would still and could still mean that the accessory be liable for the procurement of the offence, even if the concept of duress is valid in a particular circumstance. Let's illustrate this by looking at AG references, the first of the 1975 case. In this case, the accessory had been lacing the principal defendant, with drinks, with additional measures of spirits. Okay. They had done so with the knowledge that the principal defendant would be driving home. So they knew that this person was going to be driving home, and so as a result of which deliberately laced the principal defendant's drinks with more spirits than necessary, essentially, which meant that the principal defendant not only didn't know how much they had drunk, but also would get drunk incredibly quickly. They would then charged as an accessory of the offence of driving with excess alcohol, which is under Section 6, subsection 1 of the Road Traffic Act from 1972. So, of course, the principal defendant was driving under the influence of excessive alcohol and therefore was charged under this particular provision of the Road Traffic Act. But the accessory was charged by as an accessory for procuring and essentially causing this to take place. The Court of Appeal was tasked with examining whether or not there was a requirement for some kind of, quote, mental link between the two in procuring the offence. Okay, this was an argument which was presented by the trial judge, i.e. there is a mental link, there is some kind of connection between the accessory and the principal in terms of the commission of the offence. Because at the moment, and in this case specifically, the principal defendant did not know that the accessory had been lacing the principal's drinks with extra measures of spirits. It was held that the following was true. Given the words their ordinary meaning in English, and asking oneself whether in those circumstances the offence has been procured, we are in no doubt that the answer to that is that it has. It has been procured because, unknown to the driver and without his collaboration, he has been put in a position in which, in fact, he has committed an offence which he never would have committed otherwise. So this is really given the broad scope in which procuring is measured. It is talking about the concept of bringing about an offence, essentially bringing something which would essentially causing the offence to take place. And so the result of this means that there does not necessarily require this mental link between the two in the procuring of the offence, between the principal and the accessory, which was an argument which was presented by the trial judge. Welcome back, ladies and gentlemen, to our study of the criminal law. We are continuing talking about the concept of parties to a crime, the idea of secondary liability for the commission of an offence. We're going to talk in this lesson about the concept of derivative liability, which is an interesting element of the criminal law and the ideas that are related to it. We will illustrate the concept of derivative liability using a number of different cases, and then following this we're going to actually start to look at not the basic principles of criminal law and procedure, but now the substantive crimes themselves, which are part of our study. So this is our final lesson, exploring parties to a crime, and we're going to talk about derivative liability. What does derivative liability actually mean, and how is it applied in the circumstances that we are going to be examining? Well, it refers to a situation where you can have A being an accessory to the crime, or a secondary defendant, or a participant to criminal liability, where a situation such as A can be convicted of an offence as a participant, even in a circumstance where the principal defendant had not been convicted. Now, common and ordinary understanding might suggest that in order for you to be a secondary participant to a crime, it must be the case that you have a primary or principal defendant who is actually convicted of a similar offence. This is no longer the case, and this isn't the case owing to this idea of derivative liability. If you're an accessory to an offence, it is sometimes the case, should I say, that it doesn't necessarily matter if the principal defendant is or is not convicted. The idea here is that so long as you can show the actus reus of the principal offence that is committed by the principal defendant, then the idea of derivative liability could hold. What this does is it essentially allows for the act itself to have some sort of liability, even if there may not have been the prerequisite mens rea that exists in the case of the principal defendant, but that would automatically give rise to liability for an accessory to the crime, owing to this concept of derivative liability. So to show secondary participation in that regard, therefore, there only need to be proof of the actus reus of a principal offence. And one example which can illustrate this case quite nicely is the idea from Thornton and Mitchell from 1940. In this case, the principal defendant was a bus driver who was charged with the offence of driving without care and attention. The principal defendant had hit two pedestrians in the bus upon the reliance of the instructions which were provided by an accessory, we'll call A or D2. So essentially, the scene that we're setting here is that you have an accessory who is trying to essentially provide instructions to a bus driver, and the bus driver is then following the clear instructions of this accessory defendant, and in doing so, accidentally, or at least in doing so, following the instructions of this secondary defendant, hits two pedestrians with their bus. A had been careless in the information provided to the driver, despite the fact that the principal defendant was trying to act responsibly. And so we have this question here is, well, if they were trying to act responsibly, but were doing so under faulty pretenses, on the basis of the fact that they were given faulty information by this accessory, then can they be charged with the offence of driving without care and attention? It was held that because the principal defendant had paid careful attention, not necessarily to their driving, but to the instructions that had been given by the accessory, he could not be convicted of driving without care and attention. There was not this prerequisite mens rea that was present. This is the case even though they had driven into some pedestrians, owing to the fact that the accessory had been careless in their analysis. A further case comes in 1976 with the case of Hogan and Leake. The facts of this case are as follows. It was a case which involved non-consensual sexual activity between the principal defendant, P, and somebody else's wife. The wife, the victim, had been bullied into having sexual intercourse with this principal defendant by her husband, the accessory A. So the accessory A was married to the victim and had bullied and harassed and had been particularly unpleasant towards his wife, the victim, and bullied her into having sexual intercourse with this principal defendant. Now, the issues here are quite interesting because the principal defendant could not be guilty of having non-consensual sexual activity, i.e. rape or any of the other offences that are listed, owing to the fact that he had reasonable belief that the sexual intercourse in question was consensual. He had not known about the fact that the accessory had been bullying his wife into having sexual intercourse with him, and so therefore lacked the necessary mens rea. But he still had the actus reus. He still committed the offence by, i.e. committed the act, should I say, being more precise with my language, by having sexual activity with the victim. And it was held that even though the principal defendant could not be guilty of the offence, the fact that the accessory had bullied the individual into the wife, the victim, into having sexual intercourse with P, meant that A was actually guilty on the basis that he procured the offence. So even though P was not guilty, A was guilty on the basis of derivative liability. It was derivative on the actus reus of the offence. The actus reus can be shown to be proven even if the mens rea for P's liability could not. And so despite the fact that P was not guilty, he still did perform the relevant actus reus, which would have been required to prove non-consensual sexual activity, even before the Sexual Offences Act, which was obviously where this case is coming from. But the liability is derived not from the mens rea of the offence, it is derived from the actus reus itself. The final thing I want to touch on when we look at parties to a crime is this idea of ending or finishing or withdrawing from participation. What if you have a situation where you plan to commit some kind of criminal offence, and you plan and you are fully intending to be involved in the commission of a criminal offence, but then you decide against it, either before or during the commission of said offence? And this is related to the idea of withdrawing from participation. How far do you have to go to withdraw from participation such that you therefore no longer have any kind of liability? Now that's an interesting question and difficult one to reconcile, namely because the accessory to a crime has to make it incredibly clear of their intention to withdraw from participation. If this happens, then it is possible for an accessory to actually avoid liability in its entirety as a party to the crime. Now, if this is before the commission of the offence, then it could be said that it is easier to avoid liability. If it is during the commission of the offence, the general rule should be that the clearer the intention to withdraw, the more likely it is that you're going to avoid liability. And in illustrating this point, I want to just talk about the 1984 case of Whitefield. In this case, there were a number of individuals together who made a plan to commit a burglary. At some point in this process of making this plan, the accessory, someone who was part of the plan to commit the burglary, had made the decision that they did not want to go through with the planned commission of the offence. And they made this decision very clear to the other participants involved in the commission of the offence. The other participants would essentially just leave him behind and decide to go on and commit the offence without him. A would be charged as an accessory, but then would appeal his conviction on the basis that they were notified, or they had notified, their intention to withdraw from the commission of the offence. And this appeal was allowed. And the reason why this appeal was allowed was because he made it very clear of his intention to withdraw from participation. And this was done actually before the commission of the offence in question.